So first of all, I know these are really strange times, but I'm really happy to have all of you here. I know it's not a normal occasion for all of you to necessarily get together like this. These are pretty interesting times, not just with the pandemic, but the legal challenge that the city has mounted against the province because of this unprecedented council cut. So you've all collectively filed an application to intervene in the Supreme Court case. And I wanted to find out a bit more about why it is that as collective, former mayors of this city with decades of experience in municipal and other offices, you have taken on that responsibility to help with that fight. So John, I wanted to start with you. You had been working already, both behind the scenes and with a grassroots group to challenge the idea of the city being, what we call a creature of the province and seeking what we call charter city status. And I noticed that that's an integral part of the application. I hope you could speak to why you felt that that was crucial to bring to the court's attention.
Well, I had been working on the idea of a charter city status, which would mean that the city would form an agreement with the provincial government. We'd take that agreement to the federal government. We'd get them to pass, to approve that agreement under Section 43 of the Constitution as a single province amendment, so that the provincial government wouldn't be able to intrude in city affairs for all the matters set out in the charter. But I think the application that we filed, at least one of the grounds, is a lot different than the charter city status, because it asks for the Supreme Court to make a decision that while the provincial government has the mandate to deal with municipal matters under the British North America Act of 1867, that doesn't mean that a city as big and powerful with so much expertise as Toronto is really a creature of the province. And instead, in fact, a more reasonable interpretation would be that the city has some kind of reasonable autonomy to make decisions about matters of a local nature. So it's a much different idea than going the charter route. It's more for the court to interpret that section of the Constitution as saying that the city really does have some kind of autonomy, some reasonable autonomy about local affairs.
Right, and that it was not reasonable to interfere in the way that the province did. There could be some precedent setting there,
That's
perhaps,
correct.
if the court agrees.
Because we do have a City of Toronto Act, which actually said this is one of the things the city should be dealing with, governance. So the city went and had this big process to figure out what a good governance system would be. And having had that approved by the Ontario Municipal Board and by a court after a court challenge, province just said, tough luck, we don't care about what that act says. Well, it's that kind of thing that in fact we need some protection from. And that's probably true not only of Toronto, but all other large cities in Canada. I mean, we're in a position where the large cities in Canada are by far more important to the economy than anything else. And they're important culturally and all other reasons. So it's really important that those cities have the ability to actually make decisions about local affairs that stick.
And thanks so much, John. I think that really helps explain that there's sort of two key aspects to the application. And Barbara, I wanted to ask you about the other one, this interference in the election, the changing of the ward sizes to being much larger. You had the benefit of sort of representing the entire city as mayor, and I wondered if you could speak to sort of your reaction to hearing about this interference and about this new situation that councillors now have to deal with, much larger wards.
I was outraged when I learned about this at the time. For two reasons. One, that I believe that election was an opportunity for some new, bright, young, diverse candidates to be elected because there weren't incumbents in every riding. So to make council more representative of the city. But also the larger wards, the saying that municipal wards should be the same size as provincial or federal totally misunderstands the nature of the relationship and the role and the involvement of citizens and the local councillor in dealing with important issues. It's very fine and local decisions which make a big impact ultimately in the health and safety and livability of the city. So both those things, the size as well as in terms of the work that needs to be done, but also in terms of the likelihood of people from diverse communities being able to get elected and thus to have the kind of diversity on council that we really need to get things right. We need to hear from everyone.
And I just wanting to pick up on that, you spoke, I believe, in the press release about your experience working at both the federal and the local level. And that was one of the arguments that the province made. Well, this is just the same as the ridings for the provincial and federal level. And I want to know what you think about whether that makes sense as someone who's represented constituents at both levels.
Well, I think what the province has done is a shameful disregard for the needs of Torontonians. It went from constituencies of about 62,000 up to 110,000, which is the size of the federal ridings. But I don't think you can draw the same conclusions as to needs of the citizens with federal ridings versus municipal ridings in Toronto. The variety and the complexity of many of the issues that are dealt with at the local level require better representation than just 110, than a whole 110,000 people. The counselors that I talk to now are finding it very difficult to be able to keep in touch with people. And I think that's a very important part of the work that they do. Democracy, I don't think, is well served if our elected representatives are less accessible. And so I think these ridings are too large for these people, given the complexity, as I said, and variety of the issues they deal with. And quite frequently, well, MPs also deal with local issues. Quite frequently, there's a lot bigger volume of issues at the local level. Also, when it comes to dealing with many of the issues of the city, particularly the citywide issues, the city councilors have to do it on their own. They have to determine on their own how they're going to support or not support different issues, whereas the federal MPs are subject to caucus and the executive of the caucus in terms of these general policy issues. So I think it's wrong to increase the size to this level. And also the fact that you're dealing with a smaller council here gives a great advantage to the incumbents. Well, incumbents always have an advantage. There's a great recognition of names involved in people deciding who they're going to support. There's not the party affiliation that you'll see at the federal or provincial level. So this was an opportunity in going to the 47 to add more than just the incumbents, to get some new faces, to get a better representation of Toronto's population. And so by going to this larger size, those two opportunities, I think, have been lost. People are not as well served by this.
And David, you served on council most recently, and I think you've made an effort to sort of stay out of the local politics, the day-to-day stuff. I wondered if you could speak to, this is a powerhouse here of formal municipal leaders. Why intervene now? Why take this step at the court level?
I have made an effort to stay out. I've been sorely tempted at moments, but I think all of us agree that this is such significant interference by provincial government in the middle of an election to arbitrarily change boundaries that were set after a year-long consultation and engagement process with the voters of Toronto, and arbitrary in the sense that there was no consultation, there were no committee hearings. It completely abridged the province's obligation under the City of Toronto Act as it existed immediately before this. And I think we all shared that very serious concern about the process, but also about the substance. And I agree with everything my colleagues have said. I think, and we've all served as city councilors in addition to mayor, and we understand what the role is. And one of the things that perhaps we bring to the table in this court application is that understanding. Because the role of city councilors and the mayor isn't just on the floor of council. It's in the community every day. And if you look at the responsibilities of the City of Toronto, it's responsible for public transit, it's responsible for policing, it's responsible for emergency services, it's responsible for parks, it's responsible for recreation, it's responsible for social services, it's responsible for the environment, clean water. The list goes on. And almost all of those responsibilities impact on everyday lives of people living in Toronto, and often, both from a legislative perspective or from doing what is right perspective, require a city councillor to engage directly with her or his constituents. On a planning application, it's by law, and other things like the design of a swimming pool. When we rebuilt High Park Pool a long time ago, there were numerous meetings with the community. And if you have giant wards, that process, which is extremely important to actual democracy and actual service delivery, and is often demanded by residents justly, that process is almost impossible for a city councillor to do. I would argue that academically, wards of 60,000 people were extremely large when taking those responsibilities into account. Wards of over 100,000, there's a reason why in no other city in the country does it work that way. Because city government is about very intimate relationships with people. It's very important for city councillors in particular, but also the mayor, to be available to talk to constituents, listen to them, and for city councillors to work intimately with them to address local problems and challenges so they can come to a resolution that people believe in. And so both the way this was done, its arbitrariness, I would argue its illegality, and the substance of it are both so wrong that all of us felt we had to speak up and lend our voice to those who are trying to ensure that Supreme Court of Canada recognizes the role of Canada's big cities, recognizes the importance democratically to people of having a city government they can work with, and that really represents their interests on a block by block, neighborhood by neighborhood basis, not just citywide, locally as well.
Thank you to each of you for sharing and for, again, gathering virtually this way. And we'll definitely be following both the status of your application to intervene and the subsequent court hearing. So hopefully we'll talk again.
Thank you very much.
Thanks very much, Jennifer.
Thank you.
Thanks, Jennifer.
Thank you very much, Jennifer.